Number 4, no slavery. Number 5, no torture. Number 6, you have rights no matter where you go. Number 7, we're all equal before the law.
And immigration, they might approve it in a month, they might approve it in a year, they might approve it in 10 years. It's kind of like going to Las Vegas. You never know exactly how long it's going to take. But Congress writes a law, and they said the amount of time that petition is pending, so it's not the amount of time you're waiting in line, it's not the 24 years, it's just however that petition, whether it's a month, a year, or 10 years, is pending, is subtracted from the child's actual age when the family gets to the front of the line. So again, let's go back to my example for a minute, just to kind of make this as easy as possible. So she applies for her sister. 2 years later, her sister has a little girl. And then 22 years after that, her sister gets to the front of the line to get a green card. So that girl is now 22, and you can only bring your kids if they're under 21 and unmarried with you. But you can subtract the amount of time that the petition has been pending. Well, let's say she applies for 2 sisters with exactly the same facts. They both have a daughter or a son 2 years later. And one petition is pending for 5 years and it gets approved. And the other petition is pending for 5 months and gets approved. And that's a very real possibility, because the Immigration Service is a big bureaucracy. You know, I work there, she worked there. People sitting there going through tons of applications, and so some might take 5 months, some might take 5 years. It's just whatever their priorities happen to be. So the sister whose petition took 5 years, those 5 years under the Child Status Protection Act can now be subtracted from her daughter's age. If her daughter's 22, her CISPA age, Child Status Protection Act, the initials, is 17. 22 minus 5 is 17, right? So she can come with the family, but her other sister who she applied for, and it only took 5 months for the petition to go through, even though she's got to wait the same 24 years, you only can take 5 months off that child's age. So if she's 22, she's still 21 in a few months. So one family can bring their daughter with them while the other one can't, and it's all just a matter of luck. Which brings me, sorry for the long explanation, but it brings me to the point of our lawsuit. So there is a part of the law which, unfortunately, sometimes when Congress writes laws, and immigration laws are no exception, they write a kind of ambiguously, so you have to kind of scratch your head, like, what do they mean when they said this? Here's what they said. It's all one sentence, but I spent 4 years of my life arguing about this one sentence. It says that, let's say that the child that did age out, the one who is over 21, so she couldn't come with her family, it says that child can retain the original priority date. The priority date under immigration law is the date you filed the petition. So the date she initially made out the form, put the check on, put her and her sister's birth certificate and her citizenship certificate, so she could show, I'm a citizen, she's my sister, and sent that into immigration. The day they receive it is the priority date. So that's your place in line. It says the child retains the original priority date and automatically converts to the appropriate category. Well, what's that mean? Well, that's why we go to law school. It's like, okay, how do we come up with, an interpretation that makes sense, that convinces the court, and hopefully it preserves Congress's intent, which is they passed the Child Status Protection Act to keep families together. So it was Senator Feinstein actually introduced it in the Senate, and I quoted Feinstein's statement about it's all about keeping families together. So here's how we did it. We said, okay, so whatever date she applies, that's the priority date, and the daughter that turns 22, she should be able to keep that date, because the other daughter's coming with the parents, but she's not. And then the petition itself, which is the sister petition, well, again, she's not under that anymore because she didn't qualify, but now her parent is a permanent resident of the US. And permanent resident parents are allowed to apply for their sons and daughters of any age as long as they're unmarried. And if they're over 21, we call it the 2B category. So I go to the Immigration Service and I make that argument for these kids that a lot of them were from the Philippines, but Mexico, a lot of other countries have these long, long waiting lists. And I said, well, Congress now has passed the law, and the way you have to interpret this, retaining the original priority date and automatically converting to the appropriate category is, okay, it's not through the sister anymore, now it's through your parents. Now your parents have gotten green cards, and the priority date is the priority date in the sister's petition. And fortunately, it's not 24 years long. So the parents, as soon as they get the green card, they turn around and they apply for the child. Now normally that would be like a 10 to 15 year additional waiting time, but we argued that because of the Child Status Protection Act, it says the kids keep the original priority date. So they've already waited 24 years, so they've already passed the 10 to 15 years they have to wait through their mother petitioning them. So they should be able to come in a few months after the mother. And immigration says, sorry, Attorney Shusterman, nice try, but we don't interpret it like that. Who had been a clerk for Justice Souter of the US Supreme Court. He argued it. I flew out, sat at the table with him. I thought he did a great job.
Before the Supreme Court.
Before the US Supreme Court, yeah. I mean, my one and only case, you know. And I honestly think, they don't film it at the Supreme Court, but you can listen online to the oral arguments. I honestly think that, I said, you either won it 5-4 or 6-5. I just can't tell which way Kagan's gonna go or something. And then a few months later, I'm in my house. I don't know how the news always gets it, but they knew my home phone number. And they announced these decisions in Washington at 10 o'clock, which is 7 o'clock our time. And I'm not an early riser, to say the least. My phone starts ringing. I jump up at 7 o'clock in the morning, and it's like the New York Times or Wall Street Journal. I don't know, one was after the next. And they said, how do you feel about the Supreme Court decision? I said, what Supreme Court decision? They said, the one you just lost. I go, oh my God. It was a 5-4 decision written by Elena Kagan. And, you know, after I got off the phone, it was a 33-page decision, so it was hard for me to make comments. But later in the day when I read it, I saw that on page 30, she made a tremendous factual mistake. And probably working for the Immigration Service was the best training I ever got, right? And so I called up the attorney who was in Boston, and I said, we have to ask for a rehearing. This is not an opinion mistake, this was a mistake on the facts, okay? And he was very reluctant because he said, Supreme Court does not like to admit their mistakes. Our percentage of getting this reheard is less than 1%. I said, but if we do nothing, it's 0, so let's do it. So we did it, and it went on for a few weeks. He called me back, he said, maybe you got this right, because it doesn't usually go on. But in the end, they just put in a couple sentences and say, we're not going to rehear the case. One, who I'm not sorry, but he was at UCLA 2 years after I was at law school. His name's Alex Kosinski. And he got kicked off the court because he had like pornographic website or some kind of crazy thing. So, but he's the head judge on the Ninth Circuit. So he was on that panel, and there was another judge there. And when I watched it, like Kosinski, who is an immigrant himself from Eastern Europe and has quite an accent, and he is like pointing at me through the whole thing and saying, "You are not answering my question." I mean, I won't try to do his accent. "You are not answering." And I'm saying, "Your Honor, I think I am answering your question." And we're just going back and forth with this. We walked out of the room. I was with the attorney who wrote the briefs and so on. And I thought, oh my God, I hope we're not going to lose this thing. And a guy who was on the security detail follows us, and he taps me on the shoulder and he goes, "You know you lost, right?" And I said, "What do you mean, you know?" He said, "You know, I've been working here for 15 years and I know how these judges work, and you lost." And I'm thinking, oh, come on, don't buy this, don't buy this. So we had to wait a couple of months, and then in September, this is 2012, September 26th, in fact, 2012, we get the decision in the mail, and we won 6-5, as close as you could possibly imagine. We won. And then a few weeks later was the presidential election, and President Obama won, but a very slight win in 2012. Mitt Romney almost beat him. And if you look at the different ethnic groups voting, if it had just been the white vote, Obama would have lost. He would have lost. But Romney got such an overwhelming majority of the non-white vote that's how Obama got, elected. He got that. So I thought, maybe I could use that. So I was a friend of somebody on the Hispanic caucus, and right after we won the argument, or not after the election, the government hadn't said whether they were going to appeal this to the Supreme Court or not. Mm-hmm. The Hispanic caucus was meeting with Eric Holder, who is the Attorney General in the U.S., so he's the one who would make that decision. And I certainly knew that the woman on the other side, who, by the way, I left out something, and I'm sorry. My stories tend to go on, so thank you for your patience so far. They were asking her about the lines of people waiting in the different categories, like our 24-year wait. And somebody had asked her about the line of people from Mexico, how long it would take if you were from Mexico. And she just, unfortunately for her, she's not a bigoted person, but she just used this phrase where she meant we have a lot of Mexicans waiting in line, but she didn't say that. She said, we have a glut of Mexicans. And Harry Pragerson almost jumped out of his chair, and Kim Wardlow and stuff, and they go, "Did you just say a glut of Mexicans?" And she goes, "No, I mean, but it was too late. It was too late." And I thought, yeah, that's why I thought I won. I thought she just blew it right there. Anyway, they met with Eric Holder. They, of course, they didn't say, I wrote a letter, and then they improved the letter and gave it to Holder, and basically said, please, President Obama would not have won this election without a lot of people who had come in as immigrants, Hispanics, Asians, whatever, from all around the world, immigrants who became citizens and voted for him. Congress had passed this law to keep their families united. He should be the last person to want to break up the zero. And think about it, immigration is a federal law. You're immigrating to the U.S. You're not immigrating to California or to Texas. That's, you can choose where you want to live. But if the Texas court interprets the law more broadly like we wanted and the California court doesn't, if you were an immigrant, you would go to Texas, and so it wouldn't make sense. So you need one law to cover the whole country. Lawyer, I'm going to sue on behalf of all these people. So we made it into a nationwide class action, so it wouldn't just be for my clients. that everybody would be able to take advantage of what Congress passed to keep families together. And it was us and a few other law firms. I wasn't the only one who had this brilliant idea. It was about 6 of us. And we saw a district court judge in Santa Ana in Orange County. And the government spent some money and they flew one of their top attorneys out from Washington, D.C. So I'm sitting here and she's sitting there. And she got up, and I really have to give her credit because, you know, even though I totally disagree with her argument, she made things so complicated that the judge was like scratching his head, you know, and he's saying, Mr. Shusterman, you're saying that this law is not ambiguous, this is clear. And I said, well, I think it is clear, and what the courts hold, there's something called Chevron deference. Chevron's the big oil company, and it says if the statute is ambiguous, if the law is ambiguous, we look at the agency's interpretation, because they're the experts, we're judges, we're not immigration experts. However, there's a second clause to Chevron deference that says we only give them defer to their judgment if the law is ambiguous and if their explanation of the law is reasonable. And I said, well, she's saying, and this is what she was saying, the kids have to go to the back of the line again. So after waiting 24, 22 years, however you want to count it, now they're just totally out of line. They get no credit for standing in line. Their mother can apply for them, but it'll be another 15 years. And by the way, they can't get married during that 15 years, so they're going to be in their late 30s if they want to pursue this route. I said, I don't think it's ambiguous, but Your Honor, if you believe it's ambiguous, I don't think that their interpretation is reasonable. Anybody? Yeah?
So,
Yeah. You can, right now you can renew it, but you cannot apply for, they call it advanced parole. He said it will be repealed, but in 180 days. So on March the 5th of this year, DACA was repealed, but a bunch of attorneys went to court and so on. So they said they didn't repeal it in the right way. So it's knocking around courts, and the way the courts move, it's so slow. I think they're trying to keep it where it is until there's another
That was
precedent.
another case where one court said yes and the other one said no, and the one in Texas was the one that said no, wasn't it?
Mhm.
Which came
A couple other welfare programs. Basically they break it down. It's called means-tested public benefits. In other words, if your income is below a certain amount, you can qualify for different welfare programs, but only if you're a U.S. citizen. I mean, the same guy who made this stuff about race and was very sympathetic to the civil rights movement says, well, I think we should kick all these undocumented people out. And I said, okay, but just remember, people like you and I are getting the advantage of their cheap labor. And he goes, what are you talking about? I said, why don't you take a walk with me over to the kitchen and we'll see who's doing the dishes and stuff of our plates. And he looks at me and you sort of have to be in this mode day to day. But we are so dependent. I was sitting next to a movie maker, movie producer. I was having dinner with him on Sawtell in West LA at a Japanese restaurant. This guy I really admire. He had made 2 or 3 Sidney Poitier films about race and all of this. And I grew up during the civil rights era. What is that? No. And
is a little certificate of appreciation from our chapter to Carl, in recognition of your commitment to the practice of immigration law as an advocate for immigrant rights. Thank you for sharing your expertise with us as keynote speaker for today's program. So,
Thank you.
Yes.
and I'm going to
Don't
knock
step on
over.
that. I know we're at a Japanese restaurant, but it's not people who have papers that are doing the dishes. Just walk with me. He refused to do that. But